Good evening. Hi, I'm Steve Richardson, and this is the October Richardson Law Office Legal Hangout. Every month we deal with a different legal topic. This month we're handling New Jersey traffic law and DUI law. Now, in the past, we've had rotating topics of bankruptcy, student loan law, traffic law, and DUI as separate topics in different months. This month I decided to do things a little differently and combine the traffic law and DUI law topics into one, because they are somewhat interrelated. They both are handled in New Jersey municipal courts, so they're related, and I thought I'd deal with them together. And from now on, we're going to have a separate topic for our hangouts on New Jersey collection law, collection defense. And that's, so we'll have bankruptcy, collection defense, student loan law, and New Jersey and traffic and DUI law. So this month is our traffic and DUI law. Let's get to the questions. The first one is, what is an ignition interlock device? Well, this has to do with drunk driving, and is something that is used in drunk driving cases. In first defense cases, sometimes the court can choose not to impose an interlock device. In second or subsequent conviction for DUI, it is mandatory. And what it is a device that attaches to your steering wheel, and it's a little mini breathalyzer. And it has to be put on any car you own, lease, or regularly drive. And what happens is the car won't start until you blow into the tube, and it takes a reading, and you have to have a blood alcohol content of greater than 0.05. If you're above that, the car just won't start. If you're below that, then the vehicle will start, and it'll check it periodically. It's a pain, and it's you've got to use it. It kicks in obviously after your period of suspension is over, so your license is restored. But you then have to deal with this interlock device. So you blow into it. If you're okay, you don't have too high, you're not either sober or don't have a high reading, the car will start and you can drive it. For a first offense, as I said, it is discretionary with the judge. The judge can waive it. But for a first offense, you have to have the interlock device on your vehicle you own, lease, or regularly use for 6 to 12 months. For a second or subsequent offense, it's 1 to 3 years. So, and that's beyond your period of suspension. So say you have a second offense and your license is suspended for 2 years, you then have another 1 to 3 years using that little interlock device in your car. One thing to bear in mind, though, the interlock device can't tell if it's you that's driving. So if somebody else gets into a car that you own or lease or regularly operate, and that interlock device is attached to it, and they blow into it, it's not going to start. It can cause a problem. So you have to be careful of that. What I do with my clients, there's a nice brochure. It's put out by Interlock Device of New Jersey. Let's see if we get it on camera here. Interlock Device in New Jersey. It's a pamphlet. Go to www.interlockdevice.com for more information. But it's a nice little pamphlet that you can get that will give you more information on the ignition and interlock device. But that is used after your period of suspension is over, after your license has been restored, to monitor your blood alcohol level while you're driving. Second question, I was arrested for DUI. The police officer took away my cell phone when I got to the station. He gave it back later, but why did he take it? Good question. The reason he takes it is that cell phones, when they're operating, or really even when they're not operating, I have to be careful with it, can interfere with, or have the potential to interfere with, the operation of the breathalyzer machine. So they have to take that cell phone and remove it from the room where the breathalyzer is or where you're being tested, because it has the potential of causing a problem with the machine and its accuracy. The flip side of that is if they didn't take your phone away from you, so any viewers out there who were in a situation or know someone in a situation where they were arrested for drunk driving and here in New Jersey and gave a breath sample, but they didn't take the cell phone away from them, and that could be a defense, because you don't have to prove that the cell phone interfered with the breathalyzer and its accuracy, because it's only that potential to interfere that's the issue, and it can be a defense. It could result in that breathalyzer reading not being admitted into evidence. So if they didn't take your cell phone away from you, be sure to tell your DWI lawyer that they didn't, because that can be important. There's a story that was told by a very eminent drunk driving lawyer here in New Jersey about an interview he had with his client. He was trying to find out what breathalyzer machine was being used, because there had been some older models and replaced with the Alcotest, and the client wasn't really articulating it well as far as what kind of machine it was, wasn't understanding the question, and finally, out of frustration, the client took out his cell phone and held it up, and he said, "I took a picture of it. It's one of these." Well, the attorney, okay, now he knows what kind of breathalyzer it was, but now he knows the police didn't take the guy's cell phone away from him, because he has a picture of the breathalyzer machine right there on the phone. So that helped. So an important point. That's why they took it away from you. But if they didn't take it away from you, it could be a defense. Third question is, I was stopped for speeding while driving in my girlfriend's car. The officer claimed he could smell marijuana in the car and wanted to search it. When he did, he found a bag of marijuana in the center console. I didn't know it was there. Can I get into trouble? Well, I'm assuming that this was a closed console that has a lid. So nothing was in plain view. You got into the car, the lid was shut, and there's certainly a presumption that you didn't know it was there. Things in plain sight, it's in the car, it's kind of hard to deny you didn't know it was there, or it's not yours, or that sort of thing. But the police officer is going to look at your driver's license and the registration and the insurance, and they're going to see the driver's license is probably not going to match up with the registration or the insurance. He's going to run the tags in the car and find out it's owned by someone else. So in that instance, I would go to court, talk to the prosecutor, and explain that the vehicle's not, that you were driving, it's not yours, it's your girlfriend's, and that you didn't know that this marijuana was in the center console. Because think about it, I mean, you borrow someone's car and you get pulled over, you don't want to get stuck with drug possession because the person whose car you drove is a drug user. And so they have to show you knew about it, had some knowledge of it being there. So, and usually police, the prosecutors will work with you and either dismiss the case or, deal with it in some other way. So make sure that the prosecutor knows that you were not driving the vehicle. Excuse me, that it wasn't your car, it was your girlfriend's car. And usually that is on the police report. I had a case recently where that happened, where the police report indicated who the owner of the vehicle is, and it was not my client. So that's what I would do in that instance. Last question is, I was in the back seat of a car driven by someone else. The driver was pulled over for speeding. After giving the driver a ticket, he then ticketed me for not wearing a seatbelt. Can I do this? Well, yeah, you can. The law changed a while back. Used to be those in the back seat, the seatbelt law only applied to people in the front seat. But now it does apply to people in the back seat, and it's your ticket, not the driver's, and you have to pay the fine. Now, There are some defenses having to do with, if you're driving in a car that's that basically pre-seatbelt, or does not have the number of seatbelts that are now required. You couldn't buckle up. For medical reasons, you can't wear a seatbelt. There are some exceptions to the seatbelt law, and you're going to want to talk to a New Jersey traffic attorney about that to see if there is a defense. But initially, even though you're in the back seat and you weren't driving, the officer observes you're not wearing a seatbelt, that's a seatbelt ticket. So that's that. Okay, next month we're going to talk about collection issues, collection defense. If any of you have a question about student loan law or bankruptcy or any of the topics when they come up, you can certainly check out the events section of my YouTube channel at richardsonlawoffices.tv for upcoming episodes. But next month, we're going to be talking about collection law. So if you're being pursued by a creditor, you're either getting regular phone calls from collection agencies, or you're being sued, or they're touching your wages, or if you have any problems with collection, be sure to tune in next month. If you would like to get on our notification mailing list, I do send out notices to people that contact me. I can keep you up to date on the dates. It's usually the fourth Thursday of the month, but I can keep you up to date on what the topics are and the dates for broadcast. So until next month, I'm Steve Richardson, and have a good Thanksgiving and a good holiday season.